A quorum being present, the committee will come to order. Proposed rule jeopardizes worker privacy by delivering to union organizers employees' names, home and email addresses, work schedules, and other personal information. It's been almost 3 years since this proposal was first introduced, and it is just as bad now as it was back then. The board should have used this time to build public support for changing long-standing policies governing union elections. It didn't. The board should have also used this time to address the roughly 65,000 comments submitted during the last rulemaking process. It didn't. And if our Democratic colleagues truly believe the current system is broken, they should have used this time to champion a bill that would enact these changes through the legislative process, but they didn't. Instead, we are back where we were in 2011, confronting significant changes to labor law imposed through executive fiat without the consent of the American people or their elected representatives. This is the latest example of how disconnected the President and his allies are with the needs of working families. Thank you, Mr. Messenger. You're recognized for 5 minutes.
Thank you. Chairman Klein, Ranking Member Miller, and distinguished representatives, thank you for the opportunity today to testify on the NLRB's proposed ambush election rule. While the proposed rule has many flaws, which are detailed in my written statement to the committee, I'd like to focus on just 2 in my opening remarks. They diminish the ability of employees to make a free and informed choice as to whether to unionize, and they infringe on employee privacy interests. First, the very purpose of a board election is to allow employees to make a free and informed choice on whether they wish to desire to unionize or not unionize. But the primary effect of this rule will be to significantly shorten the election period between the filing of an election petition and the election itself, down to as little as 10 days. This will necessarily impair the ability of employees to educate themselves about the pros and cons of unionization before being forced to take a very important vote. The shortened time frame will also impair the ability of employees opposed to unionization to campaign themselves against the union, which is their legal right under the National Labor Relations Act. A union will obviously be fully prepared for an organizing campaign before it springs an election on a workplace. Employees, however, may be caught flat-footed and unable to counter-organize and put out their opposing messages. For example, members of this committee are obviously no strangers to election. But imagine if instead of a regularly scheduled election, any rival for your seat could simply spring an election at any time if they get a significant number of signatures, and that election would be conducted in 2 to 3 weeks after it is requested. That would not only be unfair to you as candidates in being able to get your election out, be able to get your message out before the vote, but more importantly, it would be unfair to voters who wouldn't have enough time to hear both sides of the issue before deciding who would represent them. That's effectively what the NLRB wants to impose on individual employees. And then second, the proposed rule contemplates a serious invasion of employees' personal privacy. It requires the disclosure to a union, and thus to the union's supporters and agents, of personal email addresses, personal phone numbers, and the employees' work schedules, i.e. when they get off work and when they go to work. And this information is ripe for abuse, both deliberate abuses and also unintentional abuses. First, of course, this information will be deliberately used by unions to contact individuals who have expressed no interest in being solicited by the union, or who, for that matter, may be strongly opposed to the union. In fact, that is the very purpose of these disclosures, to allow unions to contact individuals who have expressed no interest in talking to the union. And then after the election is over, nothing requires that the union give the list back to the NLRB, nor could it effectively be required. The list is then in the union hands to be able to use as they wish, perhaps for their political purposes, or to disseminate to their political allies, or for any other purpose unrelated to the election. But perhaps even worse is the unintentional abuses that could happen from these disclosures. The union will necessarily have to share this information with its agents and supporters in order to use it in an organizing campaign. And then how those individuals use it, it can be misused for wrongful purposes. I mean, for example, individual union supporters, either with or without the union's knowledge, could use this information to harass individuals who oppose the union, such as with late-night phone calls or email spam, or perhaps to simply harass individuals against whom they have a personal grudge. The disclosures will facilitate property crime, because the disclosures will include the individual's work schedules. And obviously, if someone knows when you're at work, they also know when you're not at home. And perhaps most obviously of all, these disclosures will facilitate identity theft, which is a growing problem in this nation. As the union or any of its supporters who can obtain access to this information will have enough information to sign individuals up for things, A good example is Patricia Peltier, who CWA officials, in retaliation for attempting to decertify the union, signed her up for hundreds of unwanted magazine subscriptions that she then had to go through the process of trying to cancel one by one. And there's unfortunately no way to stop these abuses from occurring once the information is given to the union. The NLRB has no effective way to police how the union will actually use this information, what safeguards are put on it, and how it is disseminated for others. And as mentioned before, once the information is given out, it can't be taken back. The bell cannot be unrung. And for this reason, the only solution to protect employees' personal privacy is for the NLRB not to require the disclosure of employees' personal information to unions in the first place. Thank you for the opportunity to testify today. I move that my written statement be included in the record, and I look forward to any questions you may have.
Thank you. All of your written statements will be included in their entirety in the record. Thank you all for your testimony.